of October 2018 for life. Now, the claimant's case is that what the defendant pays to him as monthly pension is not the correct amount of his monthly pension. In explaining the actual sum he was entitled to be paid as monthly pension, the claimant said before the passage of the payment of his pension to the defendant, the claimant's monthly pension paid to him by NITEL up to the year 2006 was the sum of 111,401.75, and between 2007 and 2011, the claimant's pension increased by 15% to the sum of 128,112.01, as reflected in the lump sum of 8,354,571 naira paid to him by the federal government as his pension for the years 2007 to 2011. For the 15% increment, the claimant relied on a circular dated 5th August 2010. Although the federal government of Nigeria suspended payment of pension to NITEL/MTEL pensioners from 2011 to 2018, when the defendant took over payment of pension, there was another federal government circular dated 26 September 2014, increasing pension by 33%. Thus, as at the time the defendant was given the responsibility to pay the pension of NITEL pensioners, the claimant's pension was the sum of 170,392.96 by virtue of 26 September 2014 circular, but the defendant was paying him the sum of 90,943 naira 6 kobo as monthly pension. It is for this reason the claimant claims in this suit that the payment of the sum of 90,943.06 to him was as monthly pension by the defendant is underpayment, and he wants the defendant to pay him all the shortfalls in this monthly pension from October 2018 to August 2021, and thereafter pay him the full amount of his monthly pension in the sum of 170,083.07 from September 2021 to life for life. The defendant's side of the case is that the salary structure under which the claimant was paid his pension by NITEL was the salary structure approved for NITEL/MTEL by the National Salaries, Incomes and Wages Commission, on the condition that NITEL will continue to fund any increases from its own funds without recourse to the government for any financial assistance. When NITEL was liquidated, the pensioners could not receive any pension for a long time until 2017, when the federal government directed the defendant to take over the management of the pension of NITEL pensioners and to verify and enroll eligible pensioners for the purpose of payment of monthly pension to them. But it was impossible to pay the pensioners' pension using a salary structure that was approved to be funded only by NITEL/MTEL. Since NITEL was no longer a legal entity, only the National Salaries, Incomes and Wages Commission can determine the salary structure applicable to ex-staff of NITEL/MTEL. According to the defendant, it started paying of monthly pension. It started payment of monthly pension to all eligible pensioners of NITEL, including the claimant, using the approved salary structure issued to the defendant by the National Salaries, Incomes and Wages Commission. The defendant said it had paid 53 months pension arrears owed to NITEL pensioners out of 84 months owed. It also averred that the 33% pension increase approved in 2010 has been applied to the claimant as shown in the claimant's computation sheet. Thus, the underpayment of pension being claimed by the claimant is as a result of the difference in the application of salary structure being applied under NITEL/MTEL as against the one approved by the National Salaries, Incomes and Wages Commission being applied by the defendant. The first relief claimed by the claimant is for a declaration that his monthly pension is 170,392.96 and that the payment of the sum of 90,946.06 to him is unlawful and a violation of law. The defendant did not dispute the allegation of the claimant that the amount the defendant pays to the claimant as monthly pension is 90,946.06. I have also seen the claimant's first bank account statement for the period 1/10/2018 to 31/10/2020. It is exhibit G1. It shows that the claimant received the monthly sum of 90,943.06 from the defendant starting from October 2018. The defendant, however, disputes the claimant's claim that his monthly pension is the sum of 170,392.96. According to the defendant, the sum of 90,943.06, it which it pays to the claimant as monthly pension, resulted from the salary structure approved for it by National Salary, Incomes and Wages Commission to be applied in the payment of the pension of NITEL pensioners. Furthermore, the defendant pleaded that 33% pension increase was approved in the year 2010, and it has already been applied to the claimant as shown in the claimant's computation sheet. The implication is that the defendant denies the sum of 170,392.96 claimed by the claimant as his monthly pension. This puts the burden on the claimant to prove that the amount he is entitled to as monthly pension is the sum of 170,392.96. When the claimant sought this court to declare that the sum of 90,943.0, which the defendant pays to him, is an underpayment of his actual
Hello, Mohammed. Mohammed, what is happening?
I think it's the network. It's the network from the network. Itu cuma capek. Apa sih pekan itu? Kan dia ngomong bekal. Saya tinggal apa buat? Oh tipe na. Saya mana rasa itu? Kuma. Ano doma? Ano di mau pekan ni?
All right. So, like I said earlier, I will get the copies across to the registrar, and then you can have your copy later today. Can you go on to the next matter, please?
Okay, madam.
The other
NSN slash
matter
ABJ
is
slash 16 is for ruling.
yes, 165M slash
165M,
23.
yes. 2023, yes.
Okay,
The parties absent, my lord. The
okay.
councils around.
Appearances, please.
We're not hearing you.
You need to unmute your mic.
Okay. May my lord
Yes,
be pleased? My
yes,
name is Ada Usman, Adah Usman.
yes.
My appearance is for the applicant. You are most grateful, my lord.
With utmost humility,
Yes,
sir.
yes.
W.O. Akenuwa. My appearance is for the respondent, sir. Thank you, sir.
And Vice Capital, on the booth, yes. Huh? Oh. Ito ko doon, hindi lang valid. Ito ko doon, ano, lang. The other lady put me, so what I'm going, outcome of the judgment.
So I'm going to read directly from the screen again, and I'm going to go straight to the decision part of the ruling.
Okay, my lord.
As God please.
As a couple.
It doesn't even appear. Well, this is a contempt proceeding instituted by the applicant, who was the eighth claimant in suit NICN ABJ 351/2014. The defendants in the suit were Nigerian Communications Commission (NCC) and Digital Bridge Institute as the first and second defendants respectively. Judgment in the suit was delivered on 11 July 2018. By a motion ex parte filed by the applicant in this court on 19 June 2023, the applicant sought leave to commence contempt proceedings against the president and secretary of the second defendant, who was the judgment debtor in the suit, for failure to obey the judgment as it relates to the applicant alone. The prayers sought in the motion ex parte were granted on 13 July 2023, and the applicant subsequently issued and served Form 86, Form 87, and a motion on notice seeking orders to commit Professor Mohammed Ajiya, President of the Judgment Debtor, and Antonia Ansa Otudo, Institute Secretary of the Judgment Debtor, for contempt. When the contempt application was heard on 5 December, it was taken together with two other applications filed by the parties. Thus, the applications to be considered and determined in this ruling, which will be in the order they have been listed below, are as follows. One, the notice of preliminary objection filed by the judgment debtor. NCC on 30th November 2023, seeking order set the Director of Finance of the NCC. And 3, the main application for committal of for contempt filed by the applicant. So we take the PO first. By the notice of preliminary objection, the second respondent judgment debtor on 30th August, filed by the second respondent, they prayed for the following orders. They wanted an order dismissing motion number ABJ 165/2023 for want of jurisdiction. 2, an order striking or dismissing the ABJ 165M for being an abuse of court process. And 3, for other orders as the court may deem fit to make. I have touched on the grounds and the arguments as it relates to the motion, the preliminary objection, as well as the reply on points of law. The contention of the second respondent is that after the initial motion, ABJ 64M, which was struck out, the applicant can only release the struck out motion with leave of court, and he cannot file a fresh motion as he has done by instituting this new proceeding or suit ABJ 165. According to the second respondent, filing these fresh proceedings instead of releasing ABJ 64 amounts to an abuse of court process. From the processes filed in respect of the PO, I find that it is not in dispute that the applicant previously filed ABJ 64M on 2nd April 2019, seeking to commit the judgment debtor for contempt. The motion was struck out by my brother, Honorable Justice O.O. Oyewumi, on 12th November 2019. The reason for striking out the motion was non-compliance with the rules of court. The law on the steps a party whose motion was struck out can take is as counsel for the applicant has stated in the reply on points of law. The party has the option of either applying to release the motion or file a fresh motion altogether, depending on the circumstances which resulted to the striking out of the motion. This position of the law was emphasized in PTW Nigeria Limited versus JBO International Limited Supra in this statement. Quote, an applicant whose motion was struck out can either file a fresh motion or file an application to release it, depending on the circumstances that led to the striking out of the motion or the nature of the order made. In this case, since motion number NICN ABJ 64M 2019 was struck out for non-compliance with the rules of this court, the motion was not a competent motion. Such incompetent motion cannot be relisted. Thus, in view of the circumstance which led to the striking out of the motion was not of a nature the applicant is entitled to apply to release. The applicant was right when he did not attempt to seek leave to release the motion. The right course of action for the applicant after the motion was struck out is to take steps to comply with the rules, which he didn't comply with in respect of ABJ 64 2019, and then file a fresh motion. Thus, the option available to the applicant after the striking out of his earlier motion is to file this fresh motion after complying with the rules which affected the earlier motion. The second respondent judgment debtor also relied on order 38, row 6, 2, and 3 of the rules of court to argue that the applicant ought to seek leave to release motion number ABJ 64M. The said rules relate to matters struck out for default of appearance. It is not the same situation which affected motion number ABJ 64M. Therefore, the provisions of order 38 rules 6, 2, and 3 of the rules of this court are not applicable to the instant proceedings. In the result, I find that the applicant's motion number ABJ 165M or this instant contempt proceedings is not an abuse of court process. The PO lacks merit and it is dismissed. Now, to the subpoena ducis tecum and ad testificandum dated 25th September 2023 and motion seeking to set aside the subpoena. On the application of of the applicant, this court issued a subpoena ducis tecum ad testificandum on 25th September 2023 to the Director of Finance of the NCC, requiring him to give evidence and produce a computed amount of the salaries and other benefits payable to a deputy manager from April 2005 to 6 March 2019 using the NCC staff condition of service. On 30th November 2023, the NCC filed a motion seeking an order setting aside the subpoena. The motion is supported with an affidavit and a written address. The applicant did not file a counter affidavit or written address to the motion, but during the hearing of the motion, counsel for the applicant submitted that the motion is incompetent because it is undated and it does not disclose who signed it. I have examined the subpoena sought to be set aside. It carries suit number ABJ 351/2014 and ABJ 165M/2023, but the parties on it are Reginald Iregbu and the claimant, and Digital Bridge Institute as the defendant. Reginald Iregbu and Digital Bridge Institute are not the only parties in suit NIC and ABJ 351/2014. Again, Digital Bridge Institute is not the only respondent in NIC and ABJ 165/2023. The instant suit in which the subpoena was issued is NIC and ABJ 165/2023, and the parties thereto are Reginald Iregbu as the applicant and NCC and DBI as the respondents. These are the parties constituted in the present proceedings. However, without any order made for amendment of the parties, the applicant caused the subpoena to be issued in these proceedings and unilaterally amended the parties mentioned on it, which is different from the parties constituted in the proceedings. To have changed the parties in the subpoena from the known parties in the proceedings without an order of court to that effect renders the subpoena incompetent and liable to be struck out for this reason. The motion filed by the NCC on 30th November seeking an order setting aside the subpoena is also infected by the same virus of changes in the parties. Accordingly, both the subpoena dated 25th September and the motion filed on 30th September are struck out. Now, to the application for contempt, committal for contempt. After granting the applicant orders to institute contempt proceedings against the principal officers, the second respondent judgment debtor at the instance of the applicant, a process titled Form 86 addressed to Professor Mohammed Ajiya, President of the Judgment Debtor, and Tonia Ansa Otudo, Institute Secretary, was issued on 14 July 2023 and served at the office of the Judgment Debtor. On 20th July 2023, another process titled Form 87, Notice to Show Cause, addressed to Professor Mohammed Ajiya, Antonia Ansa Otudo, Institute Secretary of the Judgment Debtor, was issued and also served at the office of the Judgment Debtor. The applicant subsequently filed a motion on notice praying for these orders. An order of committal to prison against the Judgment Debtor contemnor, Professor Mohammed Ajiya, Antonia Ansa Otudo, the President and Institute Secretary, for refusing to obey the order of court in the judgment delivered on 11 July. And two, an order keeping the judgment debtor in prison until they purge themselves of the contempt. The motion is supported with an affidavit and a written address. In response to the processes filed by the applicant in the contempt proceedings, the judgment debtor filed a counter affidavit and a written address to the applicant's motion for committal. I have examined the processes filed by the parties in respect of the application for committal. In determining this application, I will consider the issue whether the applicant has placed enough materials before the court with which to commit the judgment debtor principal officers for contempt of the order of this court made on July 11, 2018. The order made, which the applicant has alleged the judgment debtor failed to comply with, is the order to the judgment debtor, quote, to compute and pay to the claimants all outstanding entitlements, including salaries, allowances, and all other employment benefits accruing to the claimants in accordance with the staff condition of service issued to the claimants, unquote. In the affidavit in support of the motion for committal, it is not specifically or categorically stated that the judgment debtor did not comply with the above order of the court. Rather, the deponent, who is the applicant, merely made reference to letters exchanged between him and F of the affidavit in support of the motion for committal for contempt. It is clear to me from the averment of the affidavit is based on the outcome of the above letters exchanged between the parties. In paragraph 9 of the affidavit to show cause filed on behalf of the principal officers of the judgment debtor sought to be committed for contempt, it was deposed that the judgment debtor has satisfied the debt and does not owe on any part of the judgment. Furthermore, it was averred in paragraph 5J of the further affidavit to show cause that the judgment debtor has complied with the judgment in full. Although the applicant filed a counter affidavit to the affidavit to show cause, he did not controvert or challenge the averment in paragraph 9 of the affidavit to show cause. I have also seen Exhibit E of the applicant's affidavit in support of the motion for committal. The exhibit is a letter written by counsel for the judgment debtor on 14 June 2023, which was before the commencement of these proceedings, to counsel for the applicant in reply to the letter dated 6 June 2023. In the third, fourth, and fifth paragraphs of the letter, it was stated as follows: please be informed that the Digital Bridge Institute has paid all salaries and allowances due to your client as per condition of service referred to and as per judgment delivered on 11 July 2018. Categorically, our client wishes to state on record that your client is not owed a dime from the referred judgment, hence there is nothing to enforce. A claim of additional salary outside the approved scale is fictitious and of no basis in law. We therefore enjoin you to advise your client accordingly. From the averment in paragraph 9 of the affidavit to show cause, paragraph 5J of the further affidavit to show cause, and the content of the judgment debtor's letter to the applicant's solicitor, the judgment debtor has claimed to have paid the applicant what the applicant is entitled to be paid under the judgment. Now, I have also seen statements made by the applicant confirming that he was paid some money by the judgment debtor after the judgment. Exhibit C of the applicant's affidavit in support of the motion for committal is a demand letter written by counsel for the applicant to the judgment debtor on 6 June 2023. At the second page of the letter, counsel for the applicant wrote, please take further notice that our client has already computed what was paid thus far by Digital Bridge Institute, as same has been attached to the alongside with the certified true copy of the enrolled order. Again, Exhibit F of the affidavit of the applicant in support of the contempt motion is a letter dated 20th June 2023 from counsel for the applicant to the judgment debtor solicitor. It was stated in the second paragraph as follows: we wish to notify you that from our record, your client is yet to comply with the said judgment, as your client has not still used the condition of service of NCC to compute what was due to our client. It is clear from the content of the letters in Exhibit C and F that the applicant was paid money by the judgment debtor on the basis of the judgment of 11 July 2018. What the applicant appears dissatisfied with, as he had clearly stated in Exhibit F, is that what was paid to him was not computed using the NCC condition of service. In an application of this nature, the burden of proof on the applicant is beyond reasonable doubt, same as required in proof of criminal allegations. From the totality of the processes filed by the applicant in respect of his application for committal, the applicant has not satisfied this burden. In the first place, the applicant has not denied being paid money by the judgment debtor arising from the judgment. What is more interesting is that the letters whose content are examined above were exhibited by the applicant to support his application to commit the judgment debtor's officers for disobeying the order of court. The content of the letters disclose that the judgment debtor has taken steps to comply with the judgment. even though the applicant contends that what was paid to him was not computed in accordance with the applicable condition of service. Since the case of the applicant is that what was paid to him was not computed in accordance with the applicable condition of service, the applicant is required in this application to present his own computation of what he thinks is the correct entitlement to be paid to him. He is also required to produce, alongside the computation, the amount the judgment debtor paid to him. This is the proof required from the applicant to establish that the judgment debtor has not complied with or fully complied with the judgment. The applicant failed to do this. This failure of the applicant, in addition to the applicant's confirmation of payment of money to him by the judgment debtor after the judgment, there is nothing before the court from which to believe that the judgment debtor has not paid what is due payable to the applicant from the judgment. This is more so that the judgment itself did not specify any amount to be paid to the applicant, but put it on the judgment debtor to solely compute the applicant's entitlement and pay to him. The applicant has not presented any evidence before this court to dispute that what the judgment debtor computed and paid to him is not the correct amount of his entitlement. Therefore, I hold that the applicant did not present any concrete evidence before the court with which will warrant the court to commit the principal officers of the judgment debtor for contempt. Let me also mention that Professor Mohammed Ajia and Tonia Ansa Osudo, who the applicant sought to be committed to a correctional center for contempt, are not made respondents to the motion by which the applicant seek to commit them for contempt. Other than the mere mention of their names in the prayers in the motion, Professor Mohammed Ajia and Tonia Ansa Osudo are not made parties to the motion. Contempt proceedings are quasi-criminal in nature. The alleged contempt, no, some proceedings to the contempt proceedings. Personally served personally served the processes and must be given fair hearing. Thus, for failing to make Professor Mohammed Ajia and Tonia Ansa Osudo parties to the motion or respondents to the motion raises an issue of fair hearing. It is trite that no order can be made against a person who is not a party to a suit. See Olajide against Adeyemi 2021. In view of the parties constituted in the motion, Professor Musa Ajia and Tonia Ansa Osudo are not parties to the motion. This renders the motion which seeks to commit them for contempt incompetent. In view of the foregoing, in addition to finding the motion incompetent, I also find that the applicant failed to establish his allegation of disobedience of court order against the judgment debtor beyond reasonable doubt. In the result, the contempt proceedings lack merit, and the proceeding, that is suit number NICN ABJ 165/2023, is hereby dismissed. No order as to cost. Ruling is entered accordingly.
As the court pleases. We are most grateful, sir.
Thank you.
Thank you, my lord, for your time.
Thank you.
Thank you, my lord.
So,
we are grateful.
I guess that's it for the day. So I will leave the meeting now. Have a nice day, everybody.
Thank you,
Thank you, my lord. Mohammed, thank you. My learned friend Usman, thank you.
Thank you, sir.
Okay.
Mohammed, why are you smiling?